my friend had a bunch of
Okay, everyone, we're gonna get started with the event. Welcome, everyone. Thank you for coming out today for our Supreme Court preview, briefing event. We really interesting firm. Before we begin, just want to give a brief word about FedSoc. Federal Society is for conservative and libertarian lawyers, law students, professors interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and the duty of the judicial department to say what the law is, but not what it should be. We further this at law schools by holding debates, events, discussions, instead of following and continuing our conversations to bring important issues to the forefront of legal education. And that is why our motto is debate, discuss, decide. Today, we're going to hold a format where Mr. Shapiro will come up and give a brief speech about these current state of legal order, about the Supreme Court's term, and then Professor Green will provide commentary afterwards. And after our event concludes, there will be a time for questions, and that is also after the event concludes. So when you guys are through, unfortunately, due to law school code restrictions, you can't eat the food in the classrooms. So I have to ask you to head out of the classroom and eat at a COVID eating facility. For purposes of introduction, Mr. Ilya Shapiro is the vice president of the Cato Institute, director of the Robert A. Levy Center for Constitutional Studies, and publisher of the Cato Supreme Court Review. Before joining Cato, he was special assistant / advisor to the multinational force in Iraq on rules of law issues and practice at the Patent, Boggs, and Cleary Gottlieb. He recently authored Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. Shapiro has testified before Congress and state legislatures and has filed more than 400 amicus briefs in the Supreme Court. Before entering public practice, Shapiro clerked for Judge E. Grady Jolly of the U.S. Court of Appeals of the Fifth Circuit. He holds an A.B. from Princeton University, an MSc from the London School of Economics, and a J.D. from the University of Chicago Law School. Professor Green is a professor at our very own Temple University Beasley School of Law. He has taught and written in the fields of admin law, American legal history, civ pro, constitutional law, and federal courts. He is a two-time recipient of Temple Law School's George P. Williams Award as Outstanding Professor of the Year, and a recipient of Temple University's Lindback Award for Distinguished Teaching. He has published articles concerning wartime detention, federal common law, judicial activism, presidential interpretation, equal protection, the federal sentencing guidelines, constitutional history, the economic recession of 2008, and customary international law. He also holds a PhD from history and an MA from Princeton University, a BS from Wake Forest University, and a JD from Yale Law School. Mr. Shapiro.
Thanks very much for having me. Thanks for that introduction. It's great to be able to do in-person events again, even through a mask. Hopefully, you can still hear me. I've got these very thin gaiters. I call them my speaking masks. Normally, I have a normal mask, plane or whatever, but it's my speaking masks. We're all properly distanced, as we can see, so hopefully I won't expectorate too much. We'll be safe. Well, I want to set the stage before we talk about the term that's about to start in a couple of weeks. This last term was supposed to be the coming out party for a new 6-3 hyper-conservative Supreme Court. But despite the last day's high-profile cases that broke on such so-called partisan lines, correctly in my view, resolving issues of election regulation and donor disclosure, the term was marked largely by both surprising unanimity and never-before-seen splits or alignments of justices. There just weren't too many ideological-looking decisions, though that's partly because the more pragmatic justices crafted grand compromises. More savvy observers are calling it the 3-3-3 court, with Justice Breyer, Sotomayor, and Kagan on the left, Thomas, Alito, and Gorsuch on the right, and Roberts, Kavanaugh, and Barrett in the middle, or the center right. Now, I'm not convinced of that, not yet at least, even if that's a correct, very rough approximation of how the justices align relative to each other. And recall that the biggest recent conservative so-called betrayal was Justice Gorsuch's authorship of Bostock versus Clayton County, the employment discrimination case from 2 terms ago. And that's only if conservatives don't consider John Roberts worth counting on at all anymore. Perhaps most notably, Justice Barrett shocked doomsayers, but nobody else, by ruling according to her own brand of jurisprudence more than a particular political agenda. She joined her Democratic appointed colleagues when the law, as she saw it, demanded it, including in the 7-2 majority that rejected the latest, and I think last, existential challenge to Obamacare. So those senators, activists, and pundits who acted during her confirmation process as if she were nominated to take health care away from millions of people were either misinformed about the case or disingenuous. Interestingly, the shadow docket, that is everything except the cases that they take up for full briefing argument, the shadow docket showed Barrett's impact and frankly more split among the board on kind of ideological grounds more than the regular docket, the Sun docket. Before Justice Ginsburg died, for example, the court sustained pandemic-related restrictions on religious services, 5-4, with Roberts joining the Liberals. After Barrett joined the court, it started blocking similar restrictions, now with the chief in dissent. Barrett wasn't alone in defying expectations. When you look at the numbers, the justices were all over the place, except Kavanaugh, who was in the majority in all but 2 cases, and is definitely the man in the middle. This mishmash is the ultimate vindication of Justice Breyer, who at a Harvard lecture in April repeated that the court is a legal rather than political institution. He's now on a book tour making the same point. The court's politics avoidance tamped down calls for court packing and other radical changes, at least temporarily. But speaking of Breyer, court watchers waited with bated breath for word of whether he retired. He's the oldest justice, he's 83 now, but he's well aware of the Democrats' razor-thin Senate margins, as he's been quoted saying, I don't come from Pluto, right? He worked in the Senate, he knows what's going on. I think at the margins, pressure from progressive activists probably pushed him to stay on. Didn't want to be seen as making a political decision. And he also realizes that the Democrats have their majority in the Senate at least for another year, as narrow as it is. So I was not surprised that he didn't retire. I will be, however, if he doesn't retire next year. I imagine he will, unless he's convinced in his mind that the Democrats have at least a 2/3 chance of keeping the Senate. But that prediction is worth what you paid for it. The term had 55 signed opinions after argument, the second lowest since the Civil War. The lowest was the previous year when the court canceled arguments due to COVID. It was trying to figure out what to do. Now, of course, all last year they had telephonic arguments, starting in person this fall, though, although nobody will be allowed to attend other than counsel, the media, court personnel. Interestingly, 26 of the 55 signed opinions were decided unanimously. That's 47%, which is exactly the average for the past decade. And then when you add in the cases with just 1 dissent, you're already at 60%. So the narrative of a starkly divided court is empirically false. There were also 12 6-3 opinions and 6 5-4 ones. But there were so many different kinds of alignments. So 6 different alignments of the 6-3, 5 different alignments of the 5-4. Only half a dozen cases of the 55 were the Republican appointed justices over the Democratic appointed justices. Interestingly, here's a little trivia point that'll make me popular at bar review. John Roberts issued his first ever solo dissent in the nominal damages student speech case of Uzwegwanan versus Przewski, which is even harder to spell than it is to pronounce. But back to Kavanaugh, who was in the majority in 97% of the term's cases. The only other justices in the last half century who were in the majority that much were John Roberts the previous year and Anthony Kennedy 3 times. Now, Kavanaugh isn't a swing vote like Kennedy or O'Connor before him or others that we've sort of gotten used to having over the last decades. As I said, there were 6 different alignments in 6-3 cases, 5 different alignments in 5-4. But he's definitely at the court center. And that's even more clear when you take away the unanimous cases. He's still in the majority 95% of the time. The next closest, Roberts and Barrett, were 84% of the time. Perhaps not surprisingly, Sotomayor was least in the majority, 69% overall, and 45%, less than half in the non-unanimous cases. Like the previous year, Roberts and Kavanaugh were most likely to agree 94% of the time, and Sotomayor and Alito were least likely to agree 53% of the time. The court reversed or vacated 80% of the cases it took up. That's a really fascinating statistic. That means if the court takes a case, you're basically going to win. It's much more than half the battle. The last decade or two, the average was about 2/3, but 80% last year. The Ninth Circuit attained a magnificent 1-15 record, 94% reversal, keeping its crown as the biggest loser. Although I predict that that's not going to be the case going forward, because after the 10 judges appointed under the Trump administration to the Ninth Circuit, there are now 5 circuits with a higher ratio of Democratic to Republican appointees, and of the kind of larger ones that have a statistically significant number of cases typically each year under review. The Fourth Circuit is most likely one to start outpacing the Ninth for reversals. The one affirmance of the Ninth Circuit last term, incidentally, was the NCAA antitrust case. I'm sure a number of you are keenly interested in that. And finally, getting back to my original theme, kind of a generally somewhat conservative court, but one in flux. The liberal bloc was in the majority in 13 of the 28 non-unanimous decisions. And as I said, there were only 6 so-called partisan 6-3 splits. Okay, so that's kind of the trends and stats going into this term. So what can we expect this term? There are, as the title of this event indicated, there are really 3.5 big high-profile cases. So that's what I'll focus on. If any of you really care about, even Chevron deference or bankruptcy or some of these other things, you can ask a question. But certainly the cases that everyone's heard about involve guns, abortion, school choice, and maybe affirmative action. So the gun case, New York State Rifle and Pistol Association versus Bruin. This is the court's first opportunity to expound on the scope of the Second Amendment right to keep bear arms, since it declared that the Second Amendment protected an individual right to keep bear arms in the Heller case in 2008. 2 years later, in McDonald versus Chicago, the court extended that right to the states, but it didn't start defining the scope at all. And so finally here, we have a challenge to a New York state rule that makes it very hard to get a permit to carry a firearm for self-defense. And the question isn't going to be so much, concealed versus open, but the right to carry. And fundamentally, what is the rubric? What is the standard of review or the scrutiny level that courts are supposed to apply when evaluating challenges to Second Amendment or to the firearm regulations based on Second Amendment claims? Because the lower courts, it's not that just they disagreed on, magazine capacity limits or carry permitting or anything like that. They have, but they've also disagreed on how to evaluate such claims. Is it kind of first you see whether the asserted right is within the core right, and then does the government have a good enough justification? The justification just has to be reasonable or something, or is it a text and history kind of evaluation based on what at common law is considered to be a felony and that's disqualifying? All the courts have done different things, and in my view, the Supreme Court has been abdicating its duty and allowed certain lower courts to, in effect, practice judicial civil disobedience, not really protecting the right beyond the four corners of Heller, which is that you can't just prohibit usable firearms in the home. So this will be an important game. I'd be shocked. I think most observers will be shocked if New York didn't lose here. But what will be the standard going forward is the key question. On abortion, Dobbs versus Jackson's Women's Health. And you might have seen that today the court just announced its December calendar. So Dobbs will be argued December 1st. That takes up the question of whether a state can have any restrictions on abortion pre-viability. Now, of course, the governing standard for abortion regulation in this country is not Roe versus Wade. That case declared that there's a right under the right to privacy, right to have an abortion. But Planned Parenthood versus Casey, a 30-year-old case from Pennsylvania here, was what put in the undue burden standard. Your regulation restriction can't impose an undue burden on the right that Roe declared. What's an undue burden? Well, for a long time, it's whatever gave Justice Kennedy a headache. He's, of course, no longer there, and nobody else knows how to apply that inscrutable standard. And so, who knows what they'll do? I doubt this is going to be the case where they overturn Roe v. Wade altogether, because the deciding vote, Kavanaugh, Roberts, Barrett, to a certain extent, I think they're kind of cautious and incrementalist. Even if they want to go there, they're not going to do it in one fell swoop. So ironically, it could be that Casey is subverted or even overruled, which would kind of go back to the rubric of Roe itself. Roe v. Wade talked about trimesters and viability. So is it going to be more clearly that rather than this nebulous undue burden standard? Now, Mississippi is not hiding the ball. This case comes from Mississippi. It involves a Mississippi restriction. And it's calling for the overturning of Roe v. Wade, as do some, and some, but not all of its amicus supporters. Now, what relationship does this case have to the Texas law that's been in the news so much the last few weeks? Well, this is the case that actually will define the scope or the standard that lower courts should apply in evaluating abortion regulation. The Texas law is kind of cute and clever in terms of, there's no government enforcement. It's just anybody can have a civil suit. The challengers to the Texas law, they chose a litigation strategy whereby they didn't sue right away. They didn't set up a test case right away, clearly playing the moment for its political value rather than trying to get the law enjoined. But anyway, at the end of the day, what the court decides in Dobbs will seal the fate of Texas's SB 8. All right, moving to school choice. It's a case called Carson v. Macon, where the court looks at the constitutionality of Maine's school choice program. Now, Maine is one of many rural states that has a provision that says if your local public school district isn't providing you with an adequate education, maybe there's no high school, it's a very rural district, maybe there's no special needs programming that a student needs, what have you, then you can take that money that would otherwise be used to educate that student in the public school and take it to attend any other school, except religious ones. This is a claim based on equal protection and religious free exercise. Again, not much doubt on what the court will do when it's looked at school choice cases in the last couple of decades, when it's looked at claims that religious institutions aren't being treated the same as secular ones. Even this last term, the Fulton case about Philadelphia's adoption and foster care program that was excluding Catholic social services, the court has adopted essentially a most favored nation status requirement. That is, you don't have to have this kind of school choice program, or in the Trinity Lutheran case in Missouri 7 years ago now, about tire recycling to go to playgrounds. You don't have to have any particular kind of program, but if you do, you have to treat religious institutions the same as secular ones. So that's probably what's going to happen here. Now, I thought that after Espinoza case from 2 years ago, where the court invalidated somewhat similar Montana provision, or at least how it was interpreted by the Montana Supreme Court, that we were done with federal constitutional litigation over school choice. This probably is going to be, at this point, it's really a state litigation, but even more as a state policy debate about what to do in this area. And finally, the other case that I want to touch on, which may or may not make it to the docket this term, I'm pretty confident it will be decided by the Supreme Court eventually, but Students for Fair Admission versus Harvard, which challenges Harvard and not just Harvard, it applies to schools across the board, Ivy League and beyond. But it involves how and whether you can use racial preferences in admissions decisions. At the end of the last term, even though all was fully briefed and the court was, could have taken it up then, but instead it asked for the views of the Solicitor General. Gee, I wonder what the Biden administration will say about whether schools can use racial preferences. But that was done not, I think, earnestly with a plea for advice, but more that this kicks the can down the road, delays the ultimate decision to grant cert to take up the case. And if the court doesn't take up the case by really the second week of January is the deadline, effectively going by past practice. Then it'll be argued next term, not this term. And of course, we have midterm congressional elections next fall. So rather than having a decision on affirmative action in June 2022, we'll have argument in October 2022 with a decision in June 3. Maybe that's some sort of calculus. Of course, the Solicitor General still hasn't filed. The office has filed its brief, but we'll see when it actually gets that on file. Push the clock, punch the chess clock, and put it back into the Supreme Court's corner. If you'd like to learn about all of these cases and trends, both the ones from past term and these and others from next term, then you can watch Cato's 20th Annual Constitution Day Symposium. We just had it this past Friday. You can watch it online. In fact, I think it was broadcast on C-SPAN, so you can watch it on C-SPAN's site as well. And that's also when we released the latest volume of the Cato Supreme Court Review. And for background on the politics behind all of this, which I think is what you're going to get into, you can read my book, Supreme Disorders. Anyway, that's a sketch of the top lines of what we're most going to be looking for this coming term and where we've been. And I look forward to discussing broader issues.
Thanks. Thanks so much for coming, and thanks very much for having me. It does feel a little weird. Obviously, everything feels a little weird these days. But I have to say, being invited to a Supreme Court preview event this year feels different from all the other Supreme Court preview events I've ever done. And so I do have a few slightly different perspectives on a couple of cases, or maybe give you supplemental information about some of the particular cases that are coming forward next year. But most of what I have to say is about that. So as it turns out, the gun space, I think it's true, 2008, not coincidentally, 2008, the individual gun right gets announced for the first time by the Supreme Court of the United States. The New York gun law is about whether you need to show proper cause. I think that's the legal test, a proper cause to carry a firearm. And that law has been around for like 100 years, maybe a little bit longer than that, depending how you sort of define things, about 100 years. And that kind of law has never been struck down by, struck down. But now it might really be struck down. I think I definitely agree. I think it's likely to be struck down. And when it does get struck down, we'll learn something new about the Second Amendment. It'll be new what we learn about the Second Amendment in that case. And I look forward to it as much as anybody else. The question of the abortion cases, I think the idea is partly true that the burden sounds mushy. Of course, it wasn't designed by Kennedy, it was designed by three Republican appointees speaking together, Justice O'Connor, Justice Kennedy, Justice Souter. And the anti-burden test is old. It's not new today. I mean, it's new to me. I'm old myself. I mean, it's new. And it's not the case that people don't know how to apply it. These statutes, being to say the Mississippi statute and the Texas statute, are absolutely unconstitutional under the existing Casey framework. But it is not clear whether they are unconstitutional under the framework that these have become. The Mississippi statute regulates from 15 weeks, well below viability, which of course we would have learned is a sort of dominant final test. It moves around a little bit medically, but not much. And not 15 weeks, friends, not 15 weeks. And of course, Texas, although a lot of stuff gets made of the mechanics of implementing, 6 weeks is the Texas statute, and they're not the only ones. So what I mean to say is this issue around abortion is actually a very dramatic challenge. It's true, Mississippi says, can anything go in restricting abortion? But maybe the court won't go that far. I think there are reasons to think it won't. But whatever happens, whatever people thought the anti-burden test, it will not be after. It will not be the same thing that it was before. I think that's for sure. School of choice, absolutely. Religious rights of various kinds have been absolutely on the march. It's the signature issue of the modern Supreme Court. There will be no surprises there. It's true, I'm fascinated about Chevron and administrative law. Some people separate that class with me. I won't bore you with that. And affirmative action, I think, again, I think people are looking for a dramatic change in affirmative action. And if I could just say one small thing as a former government litigator, the idea of inviting the Solicitor General to be heard on this kind of issue is not in any way surprising. I think the Solicitor General has been encouraged to comment on all the other affirmative action cases. And this is a very important issue for America that's going to be decided. The idea of making that decision with the benefit of the Solicitor General's office, partisanship, I used to work there in a fellowship role there, and the line attorneys there actually are geniuses. I think that's true. It's my opinion. But I think the idea of getting the idea of getting the full government's opinion about things, regardless of whether it succeeds or not, I think is actually quite worthy. I might disagree a little bit about that. Of course, it does also have the Chinese feature and whatever else and so forth. But these are issues, just to be this way about it, these are issues that are going to, I think that's, they are very, very likely to be decided by the Supreme Court. And when they are decided, they will say something profoundly new about constitutional law and the status of constitutional law in the country, which again is not surprising. And that's what I really want to talk about. What I really want to talk about is this year is a tremendously remarkable year when a lot of new things on a lot of important topics will be learned and a lot of things will be shown about the court and the structure of the court. So you don't expect to come to a Supreme Court preview to hear about like legal history and legal theory. But hey, it's 2020 plus one, things are surprising these days, that's what I'm saying. So I think in a way, one of the surprising things about conservatism since Scalia, we'll just put it that way, if we go back different at a time, is I think that one of the things that really is in courts we trust. And I think there are debates about politics and elections and this sort of stuff. But I think there are reasons to think that the courts may be the most reliable branch, to put it that way, for conservative values and conservative causes. And I think that deserves a little bit of commentary. That's why I'm here. So the thing that's true is, of course, not that word. That's right. I got words. That's right. I got bored. So I think the thing that's true is it's a 6-3 court. It's a 6-3 court. That's what it is. It's a 6-3 court. It's not a 3-3 court. Of course, there are lots of cases where justices agree. Of course, there have always been lots of cases where justices agree. But on the cases that are thought to matter the most, that's the cases that are produced by. And 5-4 has been my whole life. So 5-4 wasn't infinite. 5-4 happened when Clarence Thomas succeeded Thurgood Marshall. I think in that moment, really, you had a 5-4 really during my adult kind of life. And so the structure of the court has changed in some important ways. It's worth noting, I guess, as a big picture sort of historical matter. Maybe everybody knows that since 1967 till today, there have been 20 confirmed justices in the Supreme Court. 16 of them have come from Republican president appointments, and 4 have come from Democratic president appointments, 3 of whom were on the court, and 1 of whom died. So, there is a certain sense in which it's not for any sort of necessarily pernicious sort of reason. It's the way things go. Justices come and go, and they live and die, and they retire and they don't, and they have scandals and they don't. There are lots of things you can say about that long 54-year period. But nevertheless, there is a sort of feature, it's not surprising in a way that conservatives look to the Supreme Court as for leadership, given the numbers, just the raw, bloody numbers of the whole thing. I think that's something to say. But 6-3 is new. 6-3 is something that hasn't happened before. So a real profound transformation, I think I said, when Thomas succeeds Thurgood Marshall. Another profound transformation in 2006, when Alito succeeds O'Connor. And another really extraordinary succession, obviously during the Trump administration, with the addition of Kavanaugh and Barrett. So I think this is something to think about in big sort of general terms. When you think about the court, these are the people you're thinking about. These are the people, and it does happen to. Now it doesn't just happen to actually. One part, I'm sure one shouldn't supplement one's own biography. It was a very kind biography. I really appreciate the introduction. But I did also work for Judge Garland on the DC circuit after law school, and it's on my mind. It's been on my mind. And so I think there's an incident, and we don't have to really do it if it's not worthwhile. But like there's an incident where there's a peculiarity between slowing things down for Garland and rushing things for Barrett. And I think the candid answer to that is, I think McConnell has come very, very close to saying it. I'm from South Carolina. Lindsey Graham has come very close to saying it. The real answer is, well, we could. And we did. So, and I think that really is kind of the answer in a way. And one could debate about whether one would or wouldn't or whatever you want. But I think there is a real perceived tension between the slowing down and the rushing. And I think that is an incident that I think occupies alongside the sort of broader trajectory of things. A consistent rightward shift throughout my lifetime. Pretty old guy. Throughout my lifetime, a consistent rightward shift produced by various things, and also produced by an incident that I think feels peculiar to some number of people, if that's the right way to put it. So that's happened. That's something that has happened to the court over a long period of time, and it should affect, I think, the way people think about. But we never had 6 to 3. Never have had 6 to 3 in my lifetime. It may be, to borrow this turn of phrase, it may be that conservative politicians and conservative movements and conservative organizations do not get the judges they worked for. That may be true. They haven't in the past. Justice Brennan was a Republican appointee. David Souter was a Republican appointee. Lots of people haven't panned out quite the way that sort of Republican presidents have hoped. Maybe these folks won't either. But if they don't, it'll be because the people who worked to produce them failed and were disappointed. And that's just again, I try not to be controversial. I think that's just a factual statement. I think that's very, very clear. So that's one thing that's happened. There's been a real progress in the dynamic development on the court. I think the other thing that's happened is there's been a real development organizationally. I think it's appropriate to talk about that kind of thing at a Federalist Society event, because Federalist Society has played a real role, not alone, it's done its part, but Federalist Society has played a real role in structuring conservative legal thought in ways that they were not that structured before. So, at law schools, bring in speakers to, I think would be the characterization, to provide conservative voices in an academy that doesn't have that many. I think that might be the way to say it. And when the Federalist Society has had that kind of a goal and objective, there have been national organizations among lawyers and among judges. And I think this isn't controversial either. I think the Federalist Society's involvement in the judiciary reached a pinnacle under the Trump administration. With Leonard Leo and Don McGahn, there are very vivid quotes from Don McGahn, and he's very candid, if I can put it this way, about the Federalist Society's role in selecting judges, and the idea of presenting a forum, a venue, an occasion, an institution where people can come forward and express their conservatism, so they don't have to prove it to them somewhere, in a confirmation hearing, or get quizzed about it by the White House, because they have a lifelong record of doing that kind of thing, and that makes it easier than having to sort of guess and possibly be fooled or misled, which I think is one of the things people thought about the Souter nomination, for example, just pick one. And the disorganized events that preceded the Federalist Society's, if I can call it that way, era, the Federalist Society's era. I think President Trump didn't care that much about judges, and he was very, very happy to demonstrate his conservatism and his sort of commitment to conservative values by making the Federalist Society leadership a real leader in that area. And I think that it was just exactly the way that it was. Now, this has had some consequences. And this other, I could not talk about this period of time. You've had speeches by a variety of justices. You have, just taking them chronologically, you had Amy Coney Barrett, and I'm supposed to say, who spoke at the University of Kentucky's McConnell Center in front of Senator McConnell. There's a lot of McConnell in that sentence. But anyway, as she said very emphatically, you have to understand, like the judges, the Supreme Court justices, are not a bunch of partisan hacks, she said. Okay, that's what she said. And then Steve Breyer, I don't know, I guess he passes for the left these days. Like Steve Breyer, he's one of the 4. He's definitely in the 6-3, he's in the 3. And he's doing his book tour and whatever else. And he emphatically said, you gotta understand, he says, I want you to know one thing I want you to understand, he says. The judges are not junior league politicians. That's what he says. He says that. And then Clarence Thomas, I don't often think of him in a comedic vein, but it is true he said this thing. The Supreme Court works like a car with 3 wheels. I don't know, man. I guess maybe it's a hot rod. That's all I can say. Like most cars with 3 wheels. I'm not sure what exactly the point of that was, but I think the same message in earnest. I think the message was. We're not political hacks. We're not junior league politicians. And to borrow a phrase, the center holds.
Junior varsity, isn't it? Junior league is like the women's group.
I
think junior league.
I think the quote is junior league. I think junior varsity. Do I disagree that I would have said junior varsity? I would have said junior varsity. The quote I saw, I thought said junior league. Maybe in order to not sort of place them in an academic institution. Maybe they could be minor league baseball. I don't know. Anyway, point being, all 3 of these justices, 3 justices, very different justices, one starting, one old as the hills, two quite conservative, one relatively liberal, all making these protests in public. Please don't think we're hacks. Please don't think we're politicians. Please think that the car with its 3 wheels still works. Please think that. Please do think that. And I think that this is a moment for us to think about that. And that's, of course, that's what I'm talking about. That's what I'm talking about. I can't predict any better than anybody else. I'm sure, actually, Eli can predict better than I can what exactly is going to happen next year, except for I guarantee and promise you that a year from now, we'll know an awful lot about what a 6-3 court looks than we know right now. Have there been surprises last year? Sure there was. Boston was one. I think McGirt was surprising enough. But the past is the past. That's what the historians tell us. Past is the past. And these cases coming up, these are the barbers. These are the marquee issues. These are the issues that prompted the nominations to produce the decisions that we haven't read yet. We haven't read them yet. And I've said before, and I'll say it again, they might fail. It might not turn out the way people want it to turn out. We're pushing these sorts of nominations and so forth. But then again, some of them just might. And I think especially in the area of religious freedom, I don't think anyone has any complaints. I don't think anyone who sponsors religious freedom supports a dramatic invigoration, since that's what I think is the reality, a dramatic invigoration of free exercise rights in this country. I don't think anyone's disappointed. And I don't think they'll be disappointed a year from now. And I think it's true for all the conservative nominees that have happened or whatever. There's never been another gun rights case. This year there will be. This year there will be. And they'll decide that case, and there will be something that happens. And I'll put it exactly this way. I can't predict it any more than we can. I can't predict it any more than you can exactly what it'll be. True, probably New York will lose. And that'll be a century. That'll be a century. And then we'll learn something new. Something like this. 6-3, these are times of dramatic change. These are times when I'm not as tempted to look backward and think about trends and statistics, but rather look forward at a dramatic legal constitutional change that I believe this court represents. And I believe it absolutely has not been shown. There have been inklings and whatever and so forth, and maybe it won't. But I think even, if I could put it this way, even someone encouraging us, I mean, maybe it's 3-3-3. And like, maybe it's not quite 3-3, but maybe it's like something else other than 6-3. I think even in that sort of discussion, thinking about courts of appeals is getting reversed more or less based on whether they do or don't have as many Trump appointees. I think is a certain, can I call it this, a certain political orientation that I think some number of people are open to in this country. And I think they are not crazy. I think they are not crazy. I'm not sure that they are right, but I'm sure they're not crazy. I think that's the truth. And so then I thought I'd sort of wrap it up a little bit with thinking, since this is the history stuff in a way, you know, the court has changed, the personnel in the court has changed, the decisions have changed over time. They've changed in a rightward direction. Not always as far right as the right had wanted them to move, but they have moved, really, they have moved right. Now, maybe this is the time to say, of course, you know, if you want Boston and you want to Bergefell, but maybe I'll come back to those in a minute. That's at least one issue that I think is a little bit surprising. I'll come back to that in a minute. But that's changed, I think, the organization of, if you want to call it, we can call it judicial philosophy, we can call it legal ideology. I'm going to leave open the relationship between those type of nouns in politics, since that's my whole point. Talk about the relationship between those things in politics. But I think the Federalist Society has played a central role in it, and I think that that's also worth mentioning. So this is the really part. So, as it happens, and I apologize for not having read your book, but I don't think I would be shocked to learn that politics has played a role in nominations. I think I would be.
Since George Washington.
Yeah, and in various ways since then is something I think I would say. And I think that certainly in modern times, wherever you want to start modern times, certainly in modern times, some people want to go back to Bork. We can talk about Bork. We can talk about Bork. But certainly in modern times, I think that politics have played a role in flipping. So it's really important. I don't know if there's any sort of maybe it's worth saying too. Periodically, as left progressives are upset about how predictable some of the right conservative justices seem to be. I posed to them this question: what if Kagan came out one day and was like, "No, I'm not so sure about Roe v. Wade after all. Like, so I'm just not so sure about that." You know, I think that a bunch of left progressives would feel really betrayed and would really feel upset about that. And so I think politics really does play a role. I don't think anyone had any doubts when the 4 on the 20. I don't think anyone had any serious doubts about where the 4 on the 20 stood. For example, just to pick one issue on abortion. But I think politics plays this role in selection. I think it plays a very important role. I think it plays an augmented role. I suggested reasons why. And I think the results are. And then the law is supposed to happen. But that's the thing that the courts do. They're supposed to do the law thing, which is not the politics thing. I think I heard that from 3 justices, among others. They do the law thing. And then that law thing immediately re-enters the realm of politics as people fight about it. So, you know, people will perceive a decision about gun rights and Roe versus Wade and affirmative action, and maybe not school choice anymore, because that really has been a pretty victorious issue. But maybe so, actually. I don't need to take a position about that. But, you know, that's gonna be immediately politicized again. And maybe it's worth saying, it's not that worth saying, but like if people are in the polls and like this kind of thing, you know, I think that Quinnipiac had a poll or like the Supreme Court's approval rating, which had been like it seemed rock solid for a long time, did like 37 approve and 50% disapprove. That's not too great. Gallup, I think also, although their numbers are really interesting to look at over time, but they're in a pretty low number 2, with I think like 58 moving to 49 approval, 58 to 49. So like this side of things, the political aspect of the courts on the back end, I think is also uncontroversial. I think it's uncontroversial that an awful lot of America will view the court kind of this way: politics. Politics in, politics back end. So I guess the only thing that's not politics is the law. Is the law. This decision, the moment chronologically when the court actually decides things, that's the moment when courts and judges and lawyers invite all of us to believe that what they're doing is something else. It's something not fundamentally political, something fundamentally legal in some kind of way. And I wanted for the minute to sort of, and I'm going to shut up in a minute, but like, I wanted for them to think about how it is that judges would show you. What would it take to convince sort of political people on the back end, on the front end? No, what we do really is, to borrow a phrase, no, I'm not going to borrow the phrase for a minute. They give speeches. They can like talk about what they do. They can tell you, no, really, we're seriously a 3-wheeled car. We're totally great. They can say that, no, absolutely, you're not junior league or junior varsity, perhaps more apt. Politicians, we're absolutely not political hacks. We're certainly not. No, you know what we do? We super call balls and strikes. Never minding sort of the advanced baseball analogies or whatever. Fine, we give speeches. I don't know, maybe somebody's persuaded by speeches. Maybe they are. It's hard for me to imagine it. The real answer, I think, that's being proffered these days is you have to understand we're not politicians because we're making the right decisions. And predominantly, those kinds of decisions that are characterized as correct are characterized by reference to, for example, originalism or textualism. The very products that came out of Scalia's era, Bork's era, the kind of products that have been promoted by the Federalist Society and other institutions. I think it was even introduced this way: law as it is, not as it ought to be. But textualism and originalism are used to justify radical departures from erroneous precedents of the past. So it actually is kind of that the law should be as it's supposed to be, but it's also as it was supposed to be in the past, and like never mind the stuff in the middle. So if people believe in originalism and textualism, and some people do, then making originalist textual decisions will reaffirm people's faith in law because that's correct decision making, and that proves that they're not actually influenced by politics one way or the other. But of course, everyone knows that those two methodologies themselves are, shall we say it this way, hotly controverted. Is that the right way to put it? Hotly controverted, both in the results they reach and also the validity of the methodology. So actually, if you're thinking of not just the correctness, but the perception of correctness, this stuff, at least where it's radical, may not get you there. It may not get you there. Unexpected decisions, but we don't expect the unexpected. John Roberts voted to uphold Obamacare in the middle of an election year. I was surprised. Is that wrong for me to say? I was surprised. There might be some surprises. There might be some surprises. There might be. But that's all I'm going to say about that. And then I think there is this question of fidelity to precedents. I thought about this one a little while. I was like, one of the things that convinced somebody that you're doing judging instead of law, instead of politics, or your own personal, whatever the thing that's not law is supposed to be, could be politics, could be personal preferences, or whatever the bad thing is the idea that there were things that were decided by a court before I was even here. And I'm sticking with those. Like that's one way that you could justify like the lawfulness of your decision making. And as it happens, originalism and textualism, which I've already sort of suggested, are kind of like lawnmowers. They allow you to chop down precedents that don't fit the blade height, don't actually follow. And I think that that's one of the things that sort of helps understand or explain the level of concern that people have about the 6-3 court coming into a blockbuster term in a world where precedents look vulnerable. I mean, we can go on and on. I mean, my favorite one that I think is amazing vulnerable is, Chevron. What am I getting started about Chevron? I can't stop learning about Chevron. I just want to hear about Chevron. Well, like New York Times v. Sullivan, like that case was thought to be an anchor of First Amendment jurisprudence. And there's justices on the Supreme Court like, no, how about that? And I'm like, okay. So, so I think precedents really are at risk. They're put at risk systematically by methodologies that people believe in. They believe in those methodologies. But actually, some other people don't. And so I think it's a real question. I think, he was saying, of course, it's also in the news or whatever, for whatever you think of it. But, there haven't been presidential commissions thinking about whether to impose term limits on the Supreme Court or to increase the population of the Supreme Court. That hasn't been a presidential priority, not for a long time. On the other hand, this is most definitely, I promise you this is most definitely the most conservative court since 1937, for sure, like not even controversial. It absolutely is that. And it may be much more conservative than that. And it may be much more dramatic or even radically conservative than that in terms of the methodologies of originalism and textualism going down precedents in the service of what are thought to be by the justices correct decisions. Sorry guys, I'm just doing the law thing that I see the law thing as being whack. And I think that's what to watch for in the term to come. I think that's what to watch for in the term to come. If, and to the extent that precedents survive, I think that, Americans, not just the people who support or characterize, not just the politics, should have some greater degree of confidence that law is doing something. And I think the degree to which you see relatively dramatic, relatively radical departures from precedents, even in the service of methodology that people think earnestly are totally right, like that's what it's there for. I think that doesn't seem like a very compelling. It doesn't seem like a very compelling way to think about the court's legitimacy going forward. I think there's an awful lot on the table. And I think that the cases are dramatic enough. But the point that I've been trying to make, and that's the last one, is I think the dramatic cases are actually illustrative of some deeper points about the status of the Supreme Court and about the status of law in American society. I think that's what's at stake in cases like this. And can ideas about lawfulness that have been established for some period of time with threats, not the first time there have been threats, but can those things survive in a time of dramatic change like I haven't seen in my lifetime? And you may very well see in yours.
I can say it past the 6 o'clock hour, there's no class here or what, but I just want to make a few points in response. One is I want to hear your thoughts on Chevron. I think you're thinking about American Hospital Association versus Becerra. My thought there that they'll do to Chevron what they did to Auer in the Kaiser case and say that they're upholding it completely, rewrite it basically. On the gun case, yeah, New York's had proper cause laws for a long, long time, but they meant different things. Now, proper cause means the only people who can carry in New York are celebrities, retired law enforcement, and people who have had like explicit, multiple, credible death threats, and even not always death. It's just not. It's a dead letter effectively. On the politics of it, yeah, politics has been in place from the very beginning in different ways, And one of the things that how politics has been played out is that when there's united government, meaning when the Senate and the presidency are controlled by the same party, 90% of Supreme Court nominees get confirmed. When there's a divided government in presidential election years, 20% get confirmed. So Garland was not surprising what happened to him in 2016. Barrett was confirmed in 2020, was not surprising, just based on the pure statistics. And of course, the last time that someone was confirmed to the Supreme Court by a Senate opposite the party of the president to a vacancy arising in a presidential election year was 1888. So this, again, is not about stats. This is pure, court matters. People will confirm, there's a tit for tat escalations going back now, not just the board, didn't start with Roe v. Wade. I put 1968 as a tipping point. And by the way, when you look at this, and in our legal culture, as in our political and our social culture, I love the old technology, by the way, because PowerPoint is unconstitutional. At least it has applied in 90% of cases. But anyway, this is a little arbitrary, right? Because if you go back to like 1961, make this 60 years, a rounder number, and this ratio is different. If you go forward 9 years, make this 45 years, it's a different ratio. Anyway, that's politics has always played a role in various ways. And for that matter, in the first 3 years of a presidential term, 80% confirmation rate. In the last presidential fourth year, fewer than 50%. So it's just, you can tell lots of stories with this, but it's at a certain point, it's politics all the way down. And why that is significant now is because now we have the culmination of several trends where we have divergent. This has never happened in American history. I wrote a book on it, trust me. Divergent theories of constitutional interpretation, mapping onto partisan preference at a time when the parties are more ideologically sorted than it's at least the Civil War. That's why you have all of these dynamics. That's why you have, all of this stuff. Oh, and finally, I'll open the questions after this point. Federal society has not been selecting judges. As McGann said, you're correct in invoking him as being explicit and honest about what's going on. And he was asked about this, and he said, we are not outsourcing judicial selection to the federal society. We're insourcing, meaning all the members of the White House counsel's office, the leading members of the Justice Department Office of Legal Policy, all that sort of thing. The key players in judicial selection were members of the Federal Society. So that's what defines as FedSoc picking judges. Sure, but that doesn't, it's not like, you consider me a leading member of the Federal Society. I think I'm a vice president of Cato. I give lots of speeches. I'm very prolific, all that stuff. I was not called in to, question judicial applicants. I was not called in to participate in Brett Kavanaugh's murder boards or anything like that. Yeah, they were happy to take suggestions from me. They're happy to take suggestions from anyone. But it's not the case that the FedSoc cabal got together like, who should we submit from the Western District of Arkansas? Like, no, we didn't. That didn't happen. So anyway, with that, I think I want to leave it open up to questions. Like I said, I'm happy to stay past 6 o'clock. Thank you.
I have a question. How you see the abortion case playing out in terms of what spread the justices will look like? We talked about 6-3 versus 3-3-3 and how to conceptualize the court. And I'm really curious because I think some judges are, even if they're conservative, they're more conservative about being conservative. And so I'm really curious to see how that turns out.
Right, they have different views on, where's the other slide? Precedents, right? How fast we go in any direction. Right? I don't think you can call John Roberts not a conservative. You look at his opinions in Parents Involved, the school busing case, or Fisher versus UT Austin, the previous racial preferences case, or Obergefell, he's not suddenly become a liberal. What he does is he tacks back and forth because he wants to engage in strategery to extricate the court from political debates. I'll let you decide how successful he's been in doing that. My view is that it's when judges and justices try to think about quote unquote legitimacy that they act most illegitimately. But anyway, different views on stare decisis, the strength of precedent, different views on minimalism, incrementalism, right? He didn't right away, John Roberts, disable Section 5 of the Voting Rights Act. He said in a previous case, this is constitutionally dubious. I'll rewrite the law so as not to strike it down, but Congress needed to fix it. Congress didn't fix it. 4 years later, we got Shelby County and it's disabled. Same thing with campaign finance, same thing with a whole bunch of issues. I think that you're going to see a similar dynamic with abortion. I think Roberts, probably Kavanaugh. We'll see where Barrett is on this, but they're not going to want to go a whole lot. They're going to want to vacate this decision and remand with some new standard, and then they're going to want the cases to percolate. Lawyers love percolation, right? It's a highly caffeinated profession, and so that's what's going to happen. And again, my prediction is what you're paying for.
No, I think it's gotta be right, and the thing do medical, Roberts basically seemed to accept Casey and Holden's help, which is in some ways even.
Well, no, he wrote Holden's help is wrong, but I'll hold it because of the strength of a 4-year-old precedent.
Yeah.
It's bizarre because he voted to overturn 4-year-old precedent in the past. So.
Yeah, so I was gonna say, I think it'll really come to Barrett and Kavanaugh. Barrett hasn't said, I don't think, anything on the Supreme Court, and Kavanaugh, I think, has said, he said negative things on Holden's help, but I think it's done.
And Kavanaugh, I think, has been chasing a little bit because on the eviction moratorium, where he talked about the shadow docket, he said, yeah, this is unconstitutional, but it's going to expire in a few weeks, so we'll just let it go. And then like that olive branch was slapped away, and so I think it's a little burned.
If you want to keep asking questions, that's fine. I just don't think it's so bad for having to get up and go out. So I want to thank you all for coming out. I want to thank you, Shapiro, for reading, for coming out and speaking. And I know I'm the only thing saying to you, I'll just stop at that and say thank you all for coming out for our events. Have a good evening.
Thank you.
Flying.
Oh, flying, okay.
Yeah. Yeah, I look closer to both, but also bring